Go ahead and state your appearances.
Will Kemp, Park, for Plaintiffs.
Good morning, Your Honor. Gina Wishmack for the real water defendants.
Good morning, Your Honor. Jim Kavanaugh, Gordon Reeves for ETT1, DBA Terrible Herbs.
Good morning.
Good morning, Your Honor. Colt Dodrill, Bar 9000, Counsel for Nevada Beverage.
Good morning. Okay. So I've reviewed defendants plural, joint motion for summary judgment, exhibits, plaintiff's opposition, defendants joint reply. I'll tell you what I'm inclined to do, but welcome arguments. So inclined to deny the majority, but grant in part because heirs under the statute I don't believe can get punitive damages. So I'd be inclined to grant that portion, I suppose. The remainder inclined to deny. So looking at the plain language of NRS 11.190 or E that does otherwise provide in NRS 11.215 an action to recover damages or injuries to a person or for the death of a person caused by the wrongful act or neglect of another. So under that plain language, I don't think that the wrongful death cause of action accrues until death. So I think under there you have 2 years after the death. Alternatively, this is summary judgment, discovery rule, tolling rule, genuine issues of material fact, but I think primarily under the plain language. But welcome arguments.
Thank you, Your Honor. Colt Dodrill again, Counsel for Nevada Beverage. We moved for summary judgment because this was a clear case of a case that had been filed almost 2 years after the statute of limitation expired, and the court must decide when the clock starts ticking on the statute of limitations for this case. And there's 3 issues. One, does the medical malpractice statute of limitations in 41A.097 apply? And the short answer is no. Does NRS 11.1904E, which the court just read, allow resurrection of stale injury claims? And we say it does not, because it does not specify that via its plain language that a cause of action for wrongful death does accrue upon death. It does say an action for damages. And 3, is it true that as of March 2021, Milo Hurst knew or should have known of Real Water's association with liver injury? The answer is yes, and he didn't try to find out as required by the diligence element that the Nevada Supreme Court in Adkins and prior cases had stated. And based on the court's inclination to grant as to punitive damages, it appears the court understands that Mr. Hurst, as the owner of a store that sold Real Water and as a alleged consumer of Real Water, and as a person with liver injury, knew or should have known back then, once he could not buy water for his stores, sell Real Water from his store, or purchase Real Water from himself, and he needed to find out what was causing his liver injury, and a simple search would have resulted in that. It seems the court's already there, so I'm not going to spend a lot of time on that. The focus appears to be the statutory construction, and the cases cited by plaintiff are all medical malpractice cases. Massey, which was the first one, which was limited to a medical malpractice case, and it put forth the rule for a particular purpose, and that was that a person may not know if their problems that they're suffering were caused by the doctor, or if that's just a normal part of recovery. And the Nevada Supreme Court in Massey cited Foyle v. Ballinger, which is a Utah case going back to 1987, or excuse me, 1979. And it said a person isn't going to know an apparent connection between their treatment provided by a physician and the injury suffered. And that court went on to say it would be imprudent to adopt a rule that would tempt some healthcare providers to fail to advise patients of mistakes that have been made, or make efforts to suppress knowledge of those mistakes. Those policy concerns, or those concerns in general, don't apply here. This is not a medical malpractice case. We're not in Chapter 41A. We're not healthcare providers, nor do they allege that. So the Massey case just doesn't apply. The Galloon case talks specifically, and I'm quoting from Galloon, we hold that in an action for wrongful death, the injury contemplated by NRS 41A-097 is the death of the malpractice victim, and the 2-year period of limitations begins to run from the time of death or discovery thereof. Again, we're not in medical malpractice. Medical malpractice is a whole different animal with a lot of concerns that the court and the legislature had to address. Those concerns don't exist here, and they don't work in 41A. They don't work in 11-190A. The most recent case, and plaintiffs cited, and we did as well, is Pope v. Gray. And it specifically states, we see no reason why the rule in Massey, which was the discovery rule, should not apply under the statute to wrongful death and actions for medical malpractice. Again, this is not a wrongful death action for medical practice. We are in 41. We're not in 41A. We are in either 41085 and the statute of limitations for it, which is 11-194E, which the court read. And that statute specifically states, which the court read, in an action for damages. And it specifies that those damages are for, they use the disjunctive or, the damages for, those damages, an action to recover damages for injuries to a person or for the death of a person caused by the wrongful act or neglect of another. Plaintiff is suing for injuries to the person. They're trying to seek medical specials. They're trying to seek the decedent's pain and suffering. And so we looked at the Nevada Supreme Court, and subsequent to Pope v. Gray, it came out with the Elgin case. And Elgin says whether the wrongful death statute is derivative or independent, wrongful death claims are derivative in the sense they depend on the decedent's personal injury. And in this case, the decedent's personal injury was back in 2016, and it was discovered, or should have been discovered, by 2021. So under the Nevada Supreme Court case of Elgin, in interpreting NRS 11-194E, there's nothing in there to state that the wrongful death claim outside of medical malpractice accrues upon death. It accrues upon the injury. The statute specifically says caused by the wrongful act or neglect of another. The court could look at statutes of other states and see where it says cause of action for wrongful death accrues upon the death. Nevada statute does not say that. Under the common law, there was no action for wrongful death, so it's a creature of statute, and the statute doesn't say that. And we'd ask the court not read into that, because that violates this public policy that we cite in Nevada State Bank versus Jameson. It says the purpose of a limitations period is to protect a defendant against evidentiary problems associated with defending a stale claim and promote repose by giving security and stability to human affairs. And our concern here is that when a person passes away 8 years after he's sick, at 8 years after an alleged injury, The evidence from that is gone. It's lost. There's no stability to human affairs. Somebody passes away and somebody can be sued for what they did 8, 10, 20 years before. That doesn't make sense, and that violates the Jameson family case.
So,
We'd ask that the court take a very narrow view of the wrongful death statute and a very narrow view of 11-194E and not read into it any ability to resurrect an injury claim that plaintiffs admit started in December of 2016. Thank you.
thank you. Anything from plaintiff?
Yes, Your Honor. So their argument is that a doctor kills someone, that the heirs have 2 years from the date of death. But if a defective product kills you, you have to file suit before the death.
Yeah, see,
Now,
that's
that
what
makes
that
no-
it, so you're here, so it's a little easier for me to interrupt you because you're here, and you can hear me better, but that goes to kind of what I was trying to ask Mr. Dodrill, but it's a wrongful death cause of action, right?
Correct, Your Honor.
And so I was struggling, and I still am, to understand the defense argument of, well, yeah, it's a cause of death. Or I'm sorry, it's a wrongful death cause of action, which apparently, according to them, can accrue before there's a death, I guess.
And
Am
that's
I-
not the case law, Your Honor.
Okay.
If you take a look at the Pope case, they said, quote, the very earliest that the statute of limitations can begin to run for wrongful death action would be at death and not before, unquote. You take a look at the Elgin case, which they cite as the latest and greatest. They say instead, Nevada's wrongful death scheme more closely aligns with the wrongful death statutes in states that provide a separate claim that arises upon the death of the decedent and compensates the statutory heirs for their individual loss. So it's pretty clear here that the heir claim, the summary judgment motion probably should have been brought to that. Now, their argument, and this is kind of a new argument that they were trying to tease out a little bit in the reply. Their new argument seems to be that there should be a different statute of limitations for the heir claims and a different than the estate claims. That seems to be a new argument that they really haven't developed that, Your Honor. And I would submit that doesn't make any sense. So we're going to have 2 different statutes of limitations for the same death. But assuming that that's true, that you can have 2 different statutes of limitations, we still get back to the threshold issue, which is from the Atkins case, as to whether you reasonably should have known. Okay, and Atkins and the other decisions say that's ordinarily, usually, typically a question of fact. And obviously, reasonably should have known is a question of fact. So let's take a look at the evidence they've offered to prove that Milo Hurst reasonably should have known about the real water injury back in 2000. This is their argument, that he should have known about it back in 2016 before the public health authorities knew about it, before there were any media impressions. He should have known about it back in 2016. Well, Your Honor, that argument just doesn't hold water. Their fallback position is, okay, well, maybe he shouldn't have known about it way back then, but he should have at least known about it in 2023 because of the recall that was instituted in March 21. Okay, this is a quintessential question of fact, Your Honor, whether someone reasonably should have known. And that's why I think you need to look closely at the admissible evidence as opposed to the arguments. Okay, the admissible evidence in this case are 1, the text, that we know the exact date that he had actual knowledge. He says, quote, I just found out. I just found out. Now, obviously, someone saying I just found out establishes the date of knowledge. The case is filed within 2 years of that point in time. Their only argument to get around that is to say, oh, this is inadmissible hearsay text. Your Honor, we have submitted an affidavit of, when we produced the cell phone text, an affidavit authenticating the text. There is no doubt that this was his text. If you want us to bring in experts and go through the metadata and all that, I'm fine with that. But the only challenge they have made is, oh, he's dead, so you can't admit text. That's not the law, Your Honor. So that is the paramount evidence on when he found out, him saying, I just found out. Now, the evidence they offer in the motion, the only evidence they offer in the motion are media impressions. They have an affidavit from someone saying, oh, this was in the paper a lot, it was on TV a lot, he should have known about it. Okay, well, we know that's not true from two different jury panels that came in and they filed questionnaires under oath, and 87% of them had not seen any media about this matter. Despite two prior verdicts, they had not seen any media about this matter. And I think that establishes the common knowledge of the community that with the text in and of itself, I think creates a question of fact on when he knew or should have known. Okay, the next thing they argue is, oh, Mr. Hurst sold real water. Okay, well, he sold real water like Sam Walton sold bottled water. He was an owner of a part owner of an LLC that owned a convenience store. Okay, he wasn't working in the convenience store. He wasn't a cashier in the convenience store. He was a part owner. So what they want you to do is disregard the corporate formalities, or I guess in this case, the LLC formalities, and just blur it all together. Okay, since he owned the convenience store, it's all the same. And you know, and if we're going to apply that standard and disregard corporate formalities, well, Tim Herbst and Ed Herbst and Troy Herbst sold real water just as much as Milo did because they own Terrible Herbst. So I should be allowed to sue them as sellers of real water. That's where this argument logically leads if we're going to disregard corporate formalities. Or the owners of Nevada Beverage, according to counsel, they sell real water. So I'm going to amend the complaint and bring them in here, and he's going to have to say, oh, well, Judge, there's a different rule for me. No, you have to respect the corporate formalities. What they need to do during discovery is they need to show that they sent an email warning the convenience store, okay, just like they sent to Terrible Herbst. Remember, the Terrible Herbst franchise was at the convenience store till about 2011, and then for some reason or other, the lease discontinued and it became a self-standing convenience store, not involved in Terrible Herbst. So the general policy at Nevada Beverage when there's a recall, and we know this because we've done the discovery, is that they send an email notifying the purchaser that there's been a recall. Okay, and they did. They attached the email they sent to Terrible Herbst in this motion. But Terrible Herbst wasn't operating this store after 2011, Your Honor. So we asked them, we sent a request for production to them and said, where is the email you sent to this convenience store in 2021, March of 2021? They said, we don't have an email. So the problem here is they can't prove that they followed their own recall procedure by sending the email warning the store and then taking the deposition of the store manager to say, oh yeah, I had a conversation with Mr. Hurst about it, so he knew. That's the way you would prove knowledge. They can't do that, so they're trying to leapfrog that and just asking you to disregard the corporate formalities. So that is the evidence they have, Your Honor. They have media impressions and the fact that he owned an LLC. That's it. And on the other side, like I said, we have the text, we have the jury questionnaires, we have the case law that says media impressions really don't count. You have to prove actual knowledge. That's Judge Gordon's case and some of the other cases I've cited. And to get around that, they run to the securities cases. That's securities law cases. It's completely different policy when you're trying to see when a shareholder knew or should have known about a corporate misdeed and it's disclosed in either an annual report or a 10K filing or a 10Q or something. Okay, it's a completely different thing. And no court that we've been able to find has ever held that just because there's media impressions, you impute knowledge to the person. And the case they cite, that Kentucky case, I think it was Blanton. When you take a look at that case, I mean, just compare the facts of that case with this case. In the Blanton case, which was a Superfund site in Kentucky, the two people they actually worked at the Superfund site. One was the widow of a worker and the other one was the actual worker. And the actual worker had gotten contacted by the health district and said, hey, there's environmental hazards at this Superfund site. What kind of problems have you had? He filled out a survey, okay? Those are the facts in that case where they said, oh, media impressions are some sort of evidence. That is not what happened in this case. They have no proof whatsoever that the Nevada Health District came to Mr. Hertz and said, hey, you drank real water, so you should fill out this survey. No proof whatsoever. But instead they try to leapfrog all of that, like I just said, by arguing, well, since he owned this entity, the entity must have known. And I don't know where they get that from, because I think the council will be candid enough to admit that they didn't produce any email whatsoever to show that they gave the notice that was was required under their recall policy to this particular convenience store. I don't know if it's because it's a small customer, they gave it to Terrible Herbs, they're a big customer. I don't know the reasons, but I do know that we asked them specifically for this type of evidence. They don't have it. So, Your Honor, when you look at all the facts and you start out with the proposition that it's ordinarily and typically and usually a question of fact, and you look at their facts, which are the media impressions, and you look at our facts, which are the text, the jury questionnaires, the fact that they didn't send the recall notice to the store. When you look at it, I don't see how you can grant a summary judgment on this question of fact. And that's what they're asking you to do with regards to the state claim, Your Honor. I think they need to do the discovery on it. Maybe it'll turn out better for them than I think it will. But I think, especially where you have a text that says, I just learned,
Tell me about, it seemed to me, and I did read a lot of cases for this because it's an issue that, I haven't dealt with a whole lot, to say the least, but my inclination to grant part is to the heirs apparently do not get punitive damages I
agree with that, Your Honor.
Okay.
I mean, I don't think heirs can, we to be honest, we've gone back and forth on this. We briefed this issue to the Nevada Supreme Court about 20 years ago. And we were arguing that heirs could bring a punitive damages claim. But it's really not relevant in this case because the estate's bringing the person. In some cases, the plaintiff's attorney gets contacted by the heirs, and so there's just an error. There's not a state claim for whatever reason.
But
So
this
sometimes it's relevant. It's not that relevant.
Both, right?
Yeah, here we have both the heirs and the estate claim. So to the extent that the court wants to dismiss any punitive claim for the heirs, I don't have a problem with that, Your Honor. But the punitive claim would survive in the estate. And obviously, if they've developed further evidence, they could, it's a motion without prejudice. They haven't taken any depositions. If they've got a picture of them reading the RJ on March 2021, let's see it. Okay. So they can bring it back. But for that reason, Your Honor, we would submit that the proper thing to do would be to clarify that the heirs aren't bringing a punitive claim, or to say that heirs can't bring a punitive claim, and to hold that there's a issue fact on the reasonable no claim.
Thank you very much. Any rebuttal?
Yeah, yes, Your Honor. Thank you. Colt Dodrill, bar 9,000. Counsels try to twist our recall imputed notice argument into some pierce the corporate veil. That's not what we're trying to do. What we're saying is Milo Hurst was the principal of Spring Valley Market, which was at the same address as his office. That's in the fact sheet that we produced as our primary exhibit on this. He lived above. He had leased the bottom space to Terrible Herbst through 2011. After 2011, it was his own convenience store, Spring Valley Market. That's where he allegedly purchased the product. So he would know. My analogy there is Ronald McDonald would know when they are no longer, for whatever reason, able to sell the McRib. Also in the fact sheet is their allegation that Mr. Hurst purchased water from Spring Valley Market. And my analogy is a consumer goes to McDonald's and knows hey, they don't have the McRib. And you ask, why don't they have the McRib? And if that McRib is discontinued because it caused liver injuries, you'd go, oh, wow, I should look into that. Maybe that's the cause of my problem. And counsel is disingenuous in stating that we hadn't produced evidence of the recall. We did produce receipts where my client, Nevada Beverage, and its trucks showed up at Spring Valley Market and picked up their real water product from the stores, removed it, and issued them a credit for it. So for 4 years, from March of 2021 until, well, forever after March of 2021, Spring Valley Market could not sell, did not sell, and did not have inventory to sell real water product to Milo Hurst as a consumer or anybody else. And I find it odd. I subpoenaed the company that owned Spring Valley Market, and the Kemp Jones firm objected to that on numerous grounds. And I was hoping that objection would become moot with the prevailing on summary judgment today. So we produced ample evidence that Mr. Hurst, as a consumer, was unable to purchase real water that he allegedly regularly purchased for the 4 years prior to his death. That alone gives him notice that, hey, where's the product I buy? Well, I buy real water. I drink real water. I like real water. That's my water of choice. I pick it up here and I pick it up there. But he couldn't get it. He couldn't buy it at Terrible Herbst. He couldn't buy it at Spring Valley Market. He couldn't get it anywhere. And that should get him to scratch his head and say, where is the real water that I like to buy that is my regular water of choice? It's gone. It's absent. We cited recall case law. And I can give you another example. In the 80s, Tylenol was taken off the market because there was some tampering in Chicago with cyanide that led to some deaths. A consumer of Tylenol goes to Walgreens. Hey, I can't buy Tylenol. Where is it? Where's the Tylenol? Oh, it was taken off the market. There was poison in it. Oh, my son got sick. I should look into that. That's where the recall causes the notice. And this text message, assuming it's admissible, which I say it is not, is half of the battle, because the Adkins case tells us that diligence, first of all, it says the discovery rule can be resolved as a matter of law where uncontroverted evidence proves the date by which the plaintiff should have discovered the facts. So we're here as a matter of law because it's uncontroverted that Mr. Hurst could not purchase real water anywhere for the 4 years before his death. But more so, the discovery rule says notice isn't enough. You have, and they put it first, you have to exercise due diligence. And gloriously absent from the opposition was any declaration, any evidence, any attachments showing that Mr. Hurst tried to find out what the cause was. He'd been sick in 2016. And I'm saying the statute runs in 2016, but for the discovery rule. We're giving him the discovery rule through March of 2021. And I don't care if you make it April, May, June, give him the benefit of the doubt. It doesn't matter because he didn't file it 1 week late, 1 month late, 3 months late. He filed it, I think, 23 months late. So there's no evidence of diligence here. And that is a necessary element of trying to extend this discovery rule from March of 2021, when he couldn't buy it anymore, to June of 2024, when, and this is odd, he apparently just learned about a product called Pure Water. And if we look past that for a second and say, well, maybe Pure Water is real water. I just found out there's a company in Vegas called Real Water. If that's what it had said, that doesn't mean what they think it means, because that means he just learned about a product he had supposedly been drinking since 2014. That doesn't make sense. They got sued. I hope that's not my cause. That doesn't say I've been looking and searching and trying to figure out what it was I'm trying to be diligent. It doesn't say that. It doesn't say, I've asked everybody, hey, do you know what could have caused it? I'm going through my pantry. I'm going through my grocery list. I'm going through my credit cards to see what I've eaten, what I've drank, medicines, supplements, whatever. He hasn't looked at anything. And you can't just whistle by the graveyard and wait for a review journal to land on your lap 4 years later. That's not how the discovery rule works, because it requires diligence. And in, I think it's Exhibit 3 to their opposition, they include text messages that show that Mr. Hurst was represented by Will Kemp in June of 2024. No lawsuit was filed. No Rule 27 deposition was requested. Hey, let's preserve his testimony. Let's get all this. That's not diligence. That's waiting until he passes away, and then we'll file an action on behalf of the heirs and the estate if they sign us up. That's the opposite of diligence. And so the Nevada Supreme Court in Atkins says you have to have it, and they don't have it. So I'm confused how a person that regularly drinks water doesn't know when it's no longer available in the 4 years between the recall and him passing away. So that's concerning. His office was there. I'm not making any new arguments. We filed a motion to kick out the entirety of the case. Plaintiffs came back in opposition with the jurisprudence on the medical malpractice statute. We argued that it doesn't apply. We did a evaluation in order to respond to that, and said even the estate can't get punitive damages, because if Mr. Hurst was alive right now and a party to this suit, his claim would be time barred based on the discovery rule. And for them to claim otherwise, and we're not saying there's two statutes of limitations, I'm saying there's two statutes. They are interpreted differently, and under the plain language of 11-194E, this wrongful death claim is time barred, and under the plain language of the wrongful death statute, which allows damages to certain groups, at a minimum, the punitive damages allowable to the heirs. Well, the statute does not allow punitive damages to the heirs. It allows punitive damages to the estate only under limited circumstances, and those circumstances don't apply, because had Mr. Hurst been alive today to file this lawsuit, or had been alive in February 28, 2025, he would not have been able to get punitive damages or any damages, because his claim was time barred. And there's some examples. The first case that went to trial was a Gallagher case, and there was a wrongful death claim in there. And in this case, and I lost count, we talked about it at the consolidation hearing. There's numerous plaintiffs. If any of those had passed away now, they would simply file a motion to amend. I'm not aware of any Nevada case where somebody died 8 years after the injury and was able to revive it. And to Mr. Kemp's point, if Mr. Hurst had passed away after the statute, we're still looking at almost 2 years too late. And I would ask the court to interpret it that way, and at a minimum, summary judgment on the punitive damages based on the plain language of 41-085. And we are on Zoom, so I apologize if I'm not hearing any of your questions.
I didn't have any questions on your rebuttal. Thank you. So the court's going to stick with initial inclination, deny the vast majority of defense joint motion for summary judgment, grant in part in terms of the heirs So heirs do not get punitive damages, so it's granted in part as to that. Reason for that is Nevada law on the heirs and punitive damages, and or plaintiff concedes that issue as well. The remainder, however, denied without prejudice. Primary reason under the plain language of NRS 11.1904E, which both sides and the court have all read and pointed to, but my interpretation of the plain language of E, the wrongful death cause of action does not begin to accrue until there is a death. And so that 2-year statute of limitation does not begin to run until the death. I mean, I think, I could be wrong, but I think under the plain language of statute and as interpreted under Nevada Supreme Court cases, that cause of action in an action to recover damages for the death of a person caused by a wrongful act or neglect of another. To me, the plain language says, what I just said it does. So there's that. Alternatively and or additionally, there are genuine issues of material fact as to, the discovery and tolling rules as argued in detail, and not just argued, but supported by evidence. Genuine issues of material fact is argued and supported by evidence from plaintiff on those. Court would also note that statute of limitations is an affirmative defense. Defendants then therefore have the burden there. Now I forget which case it was, but it seemed, and emphasis somewhat on seemed, it appeared to the court that notwithstanding statute of limitations being affirmative defense, it appeared, and again, I forget which case it was, but that the equitable tolling and discovery defenses to the statute of limitations, affirmative defense, the burden on showing those would be on plaintiff. But notwithstanding that, there are genuine issues of material fact, as I already noted. Defendants first have to meet their burden, no genuine issues of material fact on the statute of limitations. They haven't done that. Whether the decedent, in this case, Mr. Hurst, knew or should have known, there are genuine issues of material fact. Much of defendants' argument vis-a-vis the evidence that they set forth, attempting to demonstrate that Mr. Hurst knew or should have known, speculation, as plaintiffs have pointed out. So I agree with plaintiffs on that issue. Again, it's without prejudice. At the end of the day, we'll have perhaps more motion work or perhaps trial that'll address the statute of limitations. But at this point in time, genuine issues of material fact exist. Denied without prejudice. Plaintiffs' counsel prepare the order, submit to everybody. Thank you.